much. Thanks for that nice introduction. And welcome, everybody. We're glad that you could join us today. If you have friends who might be interested in this, as Tony said, it's going to be recorded. I am Eric Boughman, and I am joined with one of my longtime colleagues, Kathryn Jones.
Hi.
And it is our pleasure to bring you this material today. So let's jump right in. We're going to be talking about legal structuring and issues that come up that you really should be focused on early in when you're starting a business. And we say starting with the end in mind. A lot of folks have in mind they're going to start a business, and it could be just for the purposes of creating your own jobs. You never have to rely on anybody else, and that's fine. But some folks may be inclined to try to bring on employees, bring on investors, grow, get financing to grow, or maybe one day sell their business and cash out right off into the sunset or do something else. We've had several clients that have done that. Kathryn does these types of transactions on a regular basis. It's a pretty hot market right now. And as we're going through some of these issues that are coming up on some deals that just finished up and that we're currently working on, it dawned on us that oftentimes people ask at the beginning of setting up a business, why is it important that I have an operating agreement, or why do I need to have these intercompany contracts? Why is an independent contractor a written agreement? What's important about that? And then you find out when you're going to try and get investment or go get money or get somebody to give you money for the business, that folks want to see these things. Mm-hmm. And if you don't have them, the way these deals often work on as a practical matter, how the client feels it is, you get a deal to sell your business for, let's say $1 million, but you can't prove that you own certain content, or you don't have you have good agreements but ones that aren't transferable, or you have a good product or a good idea but one that's not protected, or you can't prove that you don't have anybody out there that's going to come make a claim against you later. And every time one of these little deal points happens, what's the buyer do? Takes off of the purchase price. So that's really where you feel it, is all of a sudden the deal you thought you had now, instead of being $1 million deal, is a $400,000 deal with $600,000 being held back to make sure nothing bad happens. And it's the buyers will nickel and dime you, or more than nickels and dimes, better than a car salesman. No offense to any car salesman out there. All right, so here's our agenda, and I have to give credit. Kathryn put together most of the materials for today, so thank you. And we'll start off, we'll talk here about the organizational structure of a business and why that's so important. But I like this introduction piece here. Kathryn, you want to kind of explain the thoughts here on this intro?
Sure. Right now, when someone's starting out, they may have limited funds or limited budget, or they may just not know what to expect. And so it's helpful to kind of figure out where you want to land so you can figure out how to get there. On this slide, we mentioned looking to what you will need to create value for sale or investment, and also just to make the eventual sale process a bit smoother. So with this background in mind, we're going to go into some specific issues and concerns that we see on a daily basis when clients are looking to sell their business. And it's helpful to kind of, again, have the end in mind, so you know how to map out how to get there.
And we can take a look at the end. We're going to actually go over a due diligence checklist for a deal, and you see the types of things that a buyer might want to see. So it kind of gives us a roadmap for the types of things that we want to include at the beginning. So talk about organizational structure when you're setting up a business. Now, for a lot of folks, you might you go online, you create your LLC, and you're ready to start moving, and that will work for some limited circumstances. But as you grow and as your business starts to expand, there's several ways that we can help structure the operation so that you are insulating various positions from liability. So you're separating out different business functions. And actually, a good organizational structure will help you keep things organized internally in different departments in your business. So I'll let Kathryn kind of describe this, what we're looking at here on the chart, and what the importance of this is.
So here's a format that we set up pretty regularly for clients that are coming in to start up, or if you have an existing business, you may want to branch out things into subsidiaries. going forward. So at the top level, you have a holding company. That's the parent. And we try to keep that company inactive in the operational sense. So its only function really is to hold other companies. The activity of the business would be run through one or more subsidiaries. And in this chart here, we have a segregation between the IP deployer. So those are the ones, that's the entity that's you're going to use to actually deploy your content or your IP. The middle entity here is the IP owner, and that's just going to hold the IP. It's going to be the registrant for trademarks and copyrights, and it'll license that IP that's held, then it holds to the operating IP deployer entity. Some businesses at some point they want to do kind of their back office and admin HR functions through a separate subsidiary, again, to help insulate against liability. And then it's not here on the chart, but another subsidiary could be formed to hold real estate. If the business owns its premises, you'd want to segregate that into a separate LLC. That way, if there's a slip and fall or something unrelated to the substantive business of the company, you're not exposing important assets to that claim.
That's probably the best, the easiest to understand example for a lot of folks is, let's take a dentist that wants to operate out of his own building. If that dentist opens up his dental practice in a building and operates that building all under one company or one entity, if there's a slip and fall in the building, it can affect the practice. If the practice gets sued, which isn't uncommon for any type of professional practice, whether it be a dental practice, medical practice, or a law practice, it's not all that uncommon for anybody in professional services to look at legal threats. You only want to leave exposed what you need to leave exposed, and that's the services portion, which really does not have much value at the end of the day, typically. So you're pulling out the real estate, putting that in a separate entity, you sign a lease agreement, and you keep the two of them, you treat them as separate businesses. So a claim against the service company does not affect the ownership of the holding company. Here in the chart that we see in front of us here, if you own, for instance, valuable intellectual property, if you own software, or if you have a patent, or if you wrote a book, or some type of software program that is unique, and you want to deploy that, and you have customers, and a customer or somebody out there in the marketplace wants to sue the company. If they're suing the service company, all they can get is access to whatever immediate assets are in that service company. If the service company doesn't own the intellectual property and merely licensed it, has a right to use it through some type of license agreement, we would do a written license agreement for that. So this is a great structure for protection and for ease of use, because when this is set up this way, if you have multiple owners, then we would typically put those in at the top level, at the parent company level. And then each of these subsidiaries would be wholly owned subsidiaries. It makes it a little bit easier for accounting functions, easy to manage, but it still provides a lot of protection. So as we're going through this, we'll talk about what the purpose is of some of these, of the structure and some of the agreements that we have. And we've talked about segregation of liability, defining the ownership of the assets, making sure that, and this is important through documentation as well, is understanding which entities own assets, so that if you are trying to get investment, or if you're getting a sale, or if you're entering into a transaction, you need to know what type of exposure you have and what rights each company has. I want to go back, and when we talk about the organizational documents, often people think, okay, if I just go create an LLC online and have that entity, is that good enough to protect me? And I think one of the questions you need to ask is, what are you trying to accomplish? And you get that, I'm sure you get that question a lot. Like, why even have an operating agreement, or why have written governing documents? Why do you need certificates? If the law doesn't require you to have LLC membership certificates, why should you have them? And I can come up with, and I was making some notes here, at least 4 reasons why you would want governing documents. One is you want to know who owns what and what everybody's rights are. I have been involved in lawsuits where issues in dispute involved whether a particular person who was a company employee was actually an owner, and there was no documentation to support the ownership or lack of ownership. I am involved in some issues right now involving where there's questions of ownership of the company because there's no documentation. What the rights are of the parties to the entity, specifically who has managerial control, who can call the shots in the business. Another very big issue that comes up throughout the life cycle of business is transfer rights. You know, under what circumstances, if you have more than one owner, under what circumstances can you transfer ownership? What are the limitations to transferring ownership? Let's say you bring on other investors and they're minority investors. How do you ensure that those, if you're going to sell your business, that you can sell the entire business and you can drag along those members? They're all the types of things that you can cover in your governing documents. And then finally, another point is that, and Kathryn and I talked about this before, people judge you by the way you look. If you go to a bank or you go to investors and you show them some, you know, your Sunbiz printout of your LLC, and that's what you have to offer, they're going to think that the impression is going to be that you are a minor player, and they are going to, quite frankly, try to abuse you in negotiations. If you look like you have your act together, you've seen that. What's the experience when you see somebody on the other side? It's obvious that they have prepared the documents themselves, and
it just opens it up. I mean, the buyer may think that they have more leverage than they should, or to me, having a strong set of documents just shows that you're serious, you're organized, and you're poising your business to either to grow and sell at one point, or even if you're doing bank financing, for example, they are very thorough in their diligence. And so if you need a bank loan, you're going to have to produce these governing documents. What the banks typically want to know is who's in charge and who has the authority to find the business. The last thing the bank wants to be in a situation in is if they loan all this money and then there was no authority to take on that debt. So they're going to go through a checklist, a very fulsome checklist, as would a private equity buyer, in evaluating whether or not they want to buy a business. So the governing documents are just to have them in order is so important. And if you don't have them in order, if you don't take the time to do it on the front end, you'll have to do it in the midst of a transaction or in the midst of a bank loan. And so you've got two fronts opened up. So you really want to kind of get these things in place before you start talking to third parties as far as raising capital or going to a bank to get a loan.
And what happens in the middle of a deal if a bank or somebody is asking you to create documents? Now, who's drafting the documents?
The bank.
Yeah. So they're now creating your rules.
Yep.
Versus going into a deal where you already have your rules in place and everything looks solid. They're rarely going to be questioned as long as the authority's there. But if you don't have documents, somebody else is going to have input on that.
Right.
Some of these other initial considerations, naming and availability options when you're starting your business. Not only do you want to see if the name is available in the corporate records, you want to make sure you're not going to be trading on anybody else's trademark rights. You should understand that with respect to names and trademarks, a registered trademark is great. It gives you additional protections. Everybody knows you're registered. You get to use the little fancy registration symbol when you use your name. And if somebody violates your name rights, your trademark rights, you can potentially get attorney's fees and a claim against them. But you can have trademark rights without the registration. They come about naturally through use of the business and the name in commerce. And you can have a registered trademark and actually get the registration and have it fail because of a lack of due diligence in the beginning. So name, trademarks, you want to make sure both of those contracts between subsidiaries, what are some of the most common contracts there?
We'll touch on it in more detail later, but leases, for example, in the real estate example, if you got one entity that owns the property and another entity is using the property, you want to have a written lease in between those two companies, IP licenses, permissions to use, those kind of things. The more arm's length third party it looks, the better overall, because it just shows that you're running each business separately. There's no commingling of assets or liabilities, and the structure is more sound if you can put up these walls in between the entities.
And when you're setting up, if you're starting a business and you think you may bring in, you're going to bring in investors or maybe employees. We see that sometimes where folks bring in employees and give them equity or equity rights. You should be very careful about that, by the way, because giving somebody equity rates, even 1% in the company, triggers some additional duties and responsibilities. You now owe them a fiduciary duty. And if they're an employee, you still have a duty to look out for them. They have a right to inspect books and records. There's a lot of additional issues that come up. We're not saying not to do it, but you just need to be careful with it. There are some other things that you can do instead of giving equity rights. But things that a lot of folks don't think about early on when they're setting up their company. We talked about the transferability and restrictions on sale, but restrictive covenants. If you hire people and you don't want them competing against you, or you don't want somebody, even if you don't hire them, you don't want somebody who's a shareholder in a company or a member in a company having access to your books and records and then creating a competing company. So maybe you have some non-compete provisions in your governing documents if you're an owner or officer of the company, and then the right to drag along rights. The right to, if you're going to sell, the right to compel others to sell. Nobody wants to buy 72% of your business. It's going to be an all or nothing deal.
And I also want to mention on the equity rights. Sometimes clients don't understand, or that you were to if you're an employee and you're also an owner of the business, just because your employment terminates doesn't mean your ownership rights terminate. And so one of the things that we are commonly asked to do is to figure out, okay, well, what happens when somebody leaves? They just decide, I don't want to do this anymore. Well, if their ownership terminates, you could write in your governing documents that would trigger an option in the favor of the company or the remaining members to buy out the terminated member. So just again, sometimes the clients come in, well, they were terminated, they left, but no, unless your documents say you have a right to buy them out, you really can't force them out from an equity perspective.
Now you have a former employee who had 1% or 2% interest in your company, and you terminated them and they were out of a job, and maybe you could have bought their interest for $5,000 2 years ago. The company has taken off, you've exploded during COVID, and you've now got a buyer, and it's a big buyer. What do you think you're going to pay that employee for that 2% interest?
Not $5,000. They could derail or cause a lot of havoc at a time where you really don't want havoc when you're trying to sell.
And probably not even an equal percent. You're going to overpay for that, right? I started to touch on this. Kathryn does some copyright and trademark work. We don't touch patents. We know folks who do, but on the trademarks and copyrights, what's your thoughts there as far as the early startups?
I think to get a federal trademark registration, you have to meet certain statutory requirements. Some people think that you actually have to be using the mark in an interstate commerce to try to file an application. That's not true. You could have an intent to use. There's a couple of different filing bases that are available under the trademark laws. So if you have a bona fide intent to use something, even though it's not actually deployed in the marketplace, you could still go ahead and file a trademark registration or an application on an intent to use basis. You have to start using it before the trademark registration will issue, but at least it puts kind of an early marker in the sand as to priority in case someone else comes in afterwards. So I think if you've got a mark that you think is valuable and unique, it makes sense to at least consider go ahead and filing the application as early as possible to get that process rolling. One of the things that we see in deals is, a client or a buyer wants to buy a brand. They don't want to buy just, the service, or they want to buy the brand. And so you really want to protect the brand, and an easy way to do it is to establish your rights is to have a registered trademark in place, or at least have an application going so the buyer can evaluate that and determine, how they want to handle that in the transaction.
And we're talking about technology companies here. One question that comes up I see a lot is on software. How do you protect software? You can get copyrights on software and do updates on the copyrights. There's a process for doing that. Some people may have a particular software that they're interested in getting a patent for, but keep in mind that, again, we're not patent lawyers, but there's a fundamental difference between patents and the way to protect that type of IP. And if you have a patent, then that's publicly filed and it's out there for everybody to see. And you may have some folks who try to game the system by looking at your patent and trying to deviate enough from the patent so as not to violate it, but to copy your idea. The alternative is to go the route of Coca-Cola, WD-40, and Microsoft and other companies, and that's to have very tight restrictions on confidentiality, to keep your secrets close to the vest and protect those as trade secrets. With trade secrets, that information is not public. It's still protected intellectual property. There's a different mechanism for protection enforcement, but with trade secrets, you're essentially keeping it secret, and then you're locking down anybody who has access to the information. If you want to see some interesting commentary on that, you can go back and look at the Google Waze case from a couple of years ago out west. I think it's resolved now. That's something to think about early on. Probably for a startup, you probably want to first focus on keeping your stuff as secret as possible, so you protect those secrets, even if you're thinking about doing a patent. Employment versus independent contracting, some differences there. Not only fundamental differences, but there's people want to treat independent contractors as employees and vice versa. How do you deal with that typically with clients?
There's tax considerations, I guess, which is kind of beyond the scope of this, but there's a fundamental difference tax-wise, and that kind of stems from the level of control the employer has over the employees. So independent contractors, I think you have a harder time tying them down to non-competes, because I think they're free agents in the marketplace. It's hard to tie them down. So whichever route you go in the content development arena, you want to make sure that it's clear that whatever you're hiring them to create belongs to you, the employer, or the company that's engaging the independent contractor to produce the deliverables. So in this context, I think the difference between employment and independent contracting is, I think it's just kind of part of the employment relationship is the work for hire concept is whatever the employee creates on the company's time, the company's resources, belongs to the company. On the independent contractor side, you're going to want to have some strong work for hire language that assigns the rights of the contractor, the IP rights of the contractor, to the hiring company. And that's coming up in one of the things that buyers look at is where do you show, or how can you prove that your developer doesn't have any rights to this content you're trying to sell us? Well, that's how you do it. You look at the work for hire agreements. If you have an employment agreement, just to be safe, you may want to just add some work for hire language within the employment agreement itself to make it super clear, and not have to rely on common law to establish the employer's right to that content.
And just for those who don't work in this area regularly, I know you've got a diverse group on our webinar. Work for hire is it's a term of art in connection with copyright in particular. So if you hire somebody and the work is considered a work for hire, if we go out and if we hired somebody today, for instance, to put together this webinar material to present today, if I hired a guy off of Fiverr or Craigslist and said, I want you to throw together, or a law student, I want you to throw together a webinar I'm going to present, and we present this today, that person who created it by default has equal rights and can take the same material and use it to write a book or a comic book strip, or to do a similar seminar. If they're an employee and you have an employee who's working for you, you've hired them to help with marketing and presenting seminars, then there's a different standard that applies. So in order to protect that work with independent contractors or the law student or anybody else who makes it for you, you want to treat it as a work for hire, which in the copyright law in the section specifically says it belongs to whoever the hiring party is. So you write that into your agreement. And it goes against what the common law without that agreement would say that both parties share rights to it. So it becomes very important again, especially if you're selling anything that has to do with content, marketing content, software, anything you're writing creative products. Content sourcing.
Sure.
I'll let Kathryn talk to this
Sure.
one.
We can kind of split the content between sourcing the content and deploying the content or the IP. And so under content sourcing, one of the things that buyers look at is, where are you getting your rights from? Are you purchasing the content from others? Are you licensing it from others? Are you internally developing or creating your own content or IP? So I guess the best analogy is it's like a title search, right? When you sell property, you want to make sure that all the links are there,
That's a good analogy.
establishing the ownership. And so in the content sourcing field, buyers are going to want to see how you document who owns what. And so when you source content from others, for example, you could buy it. You could buy a business that has the content that you want. You may have somebody in the marketplace who owns it, but they don't want to sell it, but they're going to give you rights to use it and market it and drive some benefit from it. And again, down here, the work for hire agreements, the content creators, you can source it from people that you hire to do it. So again, super important when you're trying to sell a tech business is being able to show that you own what you say you own, or have a right to use what you say you have a right to use.
And somebody put a comment up here, not a question, but we appreciate the comment, that in California, anyone doing work for hire is an employee. So if you hire somebody apparently if I hire somebody to create an hour-long presentation for me, they have now become my employee. I suppose that has tax implications and other employment protections that attach to that. California, I usually do have a sort of a footnote or a disclaimer that we're Florida lawyers. I'm also licensed in Nevada. We've appeared in various instances in other jurisdictions. We have contracts when we're dealing with now that's mostly going to be governed ultimately by Delaware law. But California, the Moon, there's a couple other places that just are so bizarre. We'll see if there's anybody left in California in a couple of years. That's I don't know how they're going to keep the lights on. But thank you for pointing that out. So content sourcing, documenting the ownership, very important. So somebody knows what they're buying. And then when you're going to take your content, you're going to put it into use. These are some of the different types of agreements.
So deployment, there's service agreements, what the seller is going to do for its customers, what it's going to offer, when it's going to be available, etc. And Eric, you could probably speak better on service level agreements than I can in these terms of use. But these are agreements that the seller has as far as documenting their obligations to the customer, and then what their rights are with respect to their.
Yeah, a lot of folks, what I say is on these is if you're in the technology business now, anybody has a website now, you see somebody, they put terms of use, terms of service, they might get a service level agreement or an SLA and privacy policies, and they're pulling these off the web. Again, we get it, you're a startup, you're not looking to, you want to see if you can even make any money before you're thinking down the road on what the business is going to be worth. But that being said, a way that people get in trouble, here's just a general easy way to think about this. A way people get in trouble is they put up things like a privacy policy or a service level agreement, and they don't know what's in it. And that can create problems, because if you put a privacy policy up that says you're doing something and you're not doing it, that's where you get in trouble with the FTC. You can get in trouble with your users on the internet, with potential customers. Service level agreements, a little bit different there. That usually pertains to if you're using online software platforms or something where you're going to be accessing it through some type of login code. Your service level agreement will essentially give you a certain level of guaranteed uptime, guaranteed time that it's going to be available. And if it's not available, then you might potentially be entitled to get credits. Most service level agreements, if you're just clicking on, you're signing up for a company, and here's an example that most people can understand is your cable television or your cell phone. If anybody's ever called the cable company because the cable was out and you want to complain to the cable company says, look, we have times that cable's going to be out, but here's what we're going to do. We're going to go ahead and give you a credit. And they give you a credit for 4-hour credit. Well, figure out what a 4-hour credit on your cable bill is worth, however many months there are, 17. I did the math at one point, how many hours in a month, and then divide that, you're talking about, 4 hours out of an entire month, and then your credit shows up and it's, $1.68. Congratulations. Thank you for calling and waiting on hold for 2 hours. You now have gotten your credit because you pointed out that we owe you a credit under the service level agreement. But make sure you understand when we draft these, we draft them in mind that we're trying to protect our client generally. But if somebody, I'll give you another example in terms of use where somebody went wrong a few years ago. folks now, one thing that's been in the news a lot has been the Communications Decency Act under Section 230, the CDA, in federal law. And that law essentially, the law was really written to protect website operators back in the late 90s. If I put up a website and somebody went on and they posted some obscene or pornographic material on my website where I let people post, I didn't get in trouble for it. I wasn't responsible. I was just a website. I wasn't the actual person who owned and posted the material. So if you think of YouTube, if somebody posts something obscene on YouTube, before YouTube screens it, takes it down, YouTube's not going to be liable because anybody can go post. Otherwise, it would be impossible. If I put a public billboard out or a public, let's say a post-it board in a restaurant, and somebody comes up and puts something that's offensive on that board, the restaurant's not going to be sued for it unless they leave it there, they put it up there and they leave it there for an inordinate amount of time. So that's the idea of the CDA. It's been totally abused now, but in my view, and maybe we should do another webinar talking about that. And I know I have some clients that are really fed up. It's really been abused. But in any event, I had an issue come up several years ago or a few years ago with a client that there was some defamatory material posted on the website of a newspaper of all places. And they would normally have been protected on their website by the CDA, except in their terms of service, they went the other direction and they said that they own all content that was posted on their website. And so whenever you post something there, they own it and they have all rights to it. Well, I took the position that by owning the content, you're now responsible for it, you're liable for it. So you're no longer covered. You can no longer claim, well, we didn't put the content there, it's not ours, we're just a platform, we're protected by the CDA. And I was able to at least use that to put for some pressure. I'm not saying that would be a successful argument today. I think the courts have gone the wrong direction generally, but that's an example of having stuff in your terms. So anyway, point is read this stuff. If you don't want to read it, then get a lawyer, hire somebody to do it at least for a short amount of time. Third-party vendors, these are other agreements. And when you're dealing with vendors, the big issue there is making sure that they're protecting your information and know who you're dealing with. You don't want the big Equifax breach, I think a couple years ago, that came through a third-party vendor. And when you have third-party vendors doing services for you, just like independent contractors, a buyer in a deal or somebody who's coming in to evaluate your business is going to want to look at those contracts, and they're going to want to make sure if they're saying, well, you're protecting all the data that you have at your availability, you better be able to say, yes, I'm protecting it, and I've already reviewed the terms and the agreements, and I know who I'm doing business with, so I know they're protecting it as well.
And in the purchase documentation, you may actually be required to make a formal representation as to your vouching that your third-party providers are doing X, Y, and Z. And so it's another reason to make sure you're doing business with reputable, established providers. So it's a little bit easier to make that representation to the buyer.
Yeah, if they say, well, let's find out who your host is for your main content, and it turns out that it's I don't want to disparage any particular companies or regions of the world, but if it's a company that's not trusted, or if it's from a region that's not trusted, again, it's another way that a buyer is going to, it gives a buyer a reason to knock down the price, it gives a bank a reason to say no, it gives an investor a reason to say, I want, if I'm going to take on all this risk and invest money, I want a bigger percentage. It changes the leverage, it changes the deal points, and it could make you lose a deal. Let's see, did I skip too far? There we go.
You did.
All right, okay, with documented relationships, affiliated companies. So this goes back a little bit to our deal structure, and we basically, by having things documented, you're creating fences. It's kind of the idea of having, if you're going to own the business and you're going to operate your business in a structure, in a piece of real estate that you own, you want to have a written lease. Yes, you got to pay sales tax in Florida and probably some other places. And yes, it's a little bit of extra work, but by having that written lease, you've now created two distinct businesses, and you've been able to separate one from the other. And sometimes you may want to sell. You may be in a situation where, if I use the dental practice, I'm using the hard, real estate and business example. You want to sell the dental practice, but I want to keep the building. I want to rent out to the new buyer. Makes it much easier to do that. If you are a technology company, maybe you want to sell some of the services to the technology company. You want to sell that service line. If you're a marketing company, for instance, You want to sell the marketing business, but you've developed some cool technology that supports the marketing business, and you want to keep that technology. It allows you to do that in a much more streamlined fashion. And it also, again, it creates protection against liability. We're always trying to do that as lawyers, is decrease your liability and then maximize your value when it comes time to cash in on the value. Anything else we need to hit on there, you think? Okay. And if you guys got any questions, fire away. Also, you can, if you don't think of it now, but you have a question afterwards, please hit us up. Again, thank you for joining us. We have some folks that came in a little bit later. This entire webinar will be recorded, and if you'd like a copy sent to you, email Kathryn or I. Be sure to get that out to you. So, due diligence. So now you're in a position, you've been operating for a while, and you've got somebody who's interested in investing in your business, or loaning, or buying your business, or loaning to your business. This is the type of stuff that they're going to want to look at specifically. This is what your list is going to look like. Kathryn, I'll just take it away.
Sure, and the list could be pages and pages and pages long. So towards the end of the slide presentation, we've excerpted a few due diligence inquiries relating to tech companies specifically, but just keep in mind that that's a smaller part of a much larger list. So legal due diligence, that's what, and we're the lawyers, we're the ones that are familiar with this process more so than, you know, accounting or financial or human resources diligence, which is mentioned in the next slide. But so what does a buyer look for? Again, they want to look at your governing documents. They want to figure out your structure. They want to figure out who's involved, who's going to have to sign to agree to sell the business. They're going to want to know who the key players are, so they may want to retain them after the sale for a consulting role or some other kind of active role in the company once the buyer has purchased the business. They also look for liens, encumbrances on your assets. The diligence process involves running lien searches to figure out, you know, what needs to be cleared up to get free and clear title to the buyer at the end of the day. Item 3, content sourcing, we talked about that. You want to be able to, as a seller, point to something and say, I own this and here's why, and here's how it's documented. And then Eric can speak to this as existing litigation. The buyer's going to want to know what issues there are, what they could be stepping in. And again, if there's a lot going on, that could have an impact on the purchase price that's paid to the seller at the end of the day.
And having framing that a certain way sometimes is as much an art as just putting the information out there. And I'll use that last one, the existing litigation, as an example. Again, if we're on the side of representing a buyer and we're helping them look at, try to figure out if they want to do business with somebody. This might be from, you know, if they're a buyer, if they're just trying to determine whether to enter into a long-term agreement with somebody. Again, it doesn't have to be in technology or on the web. It could be a landlord deciding if they want to rent to a tenant. If you're looking at somebody's litigation history, and you can search some of this publicly, it's part of the reason why I'm moving more and more towards alternative dispute resolution, including arbitration, because it's not easily searchable. But if you're looking at existing litigation and you see you're about to do business with somebody that's been operating for 20 years and they've never been involved in a lawsuit, looks great. Been involved in 1 or 2 lawsuits, okay. If they've been open for 5 years and they've been involved in 17 lawsuits and they've been the plaintiff and, you know, more than half, it doesn't even matter at that point. You, as somebody looking to do business with somebody, you're just getting involved with somebody who has been in a lot of fights, and it sends a signal. So if you have that situation, and we just drafted some documents recently with you know, talking about a couple of lawsuits, and we were very specific about what the point of each lawsuit was, where we were the plaintiff. Why was it filed? How long did it go on? What was the goal? And we write that, we try to write it in a persuasive way to send a message to the folks, not long, but just send a message to the folks that are looking at it to say, yeah, look, we're not a problem here. This was a problem that was foisted upon us, and this is how we dealt with it quickly and efficiently.
Also, I think when it comes to IP and protecting your IP, you have to be proactive in protecting your marks.
That's right.
So if you have litigation going on and you're trying to enforce your marks, I think it shows to a buyer that, hey, we're serious. We're doing what we can to make sure we're protected, and it may not be enough to have a registration. If someone is out there actively infringing on what you're doing, then you have to take an action to counteract that. And a buyer is probably, you know, buyers may shy away from litigation, but in that context, they're going to say, hey, this this business is serious and it's adding value because there's already an aggressive plan in place to protect our IP.
Yes, and you could, that's a great point. You could potentially waive those protections if you don't protect it. You could waive your registration protections and so forth by not protecting your intellectual property. So you do have to take steps sometimes. Some of the other due diligence. Now, we often come in contact with folks who want to do everything. The lawyer who does, everything from criminal to immigration to wills and trusts to corporate, and they've done all this in their last 2 years. We don't. It's very difficult, I think, to be a master of everything. So we tend to go by the motto of staying in our own lane with respect to what our areas of expertise are, which are on the legal side. So when it comes to accounting and financial, we are often working with an accountant or with the financial, the folks who have the knowledge financially, whether that be CFOs, the accountants, or other folks with that area of expertise. But these are other issues and questions that people will look at. They'll want to see your financial documents. How they're described is a big deal. So Kathryn's been involved in a deal where there's a lot of back and forth on what the accounting standard is. And I think sometimes that's maybe from just a lack of understanding of the fact that there are certain terms of art that you have to be careful when you use them, like work for hire, or like in accounting, GAAP is a common term of art. Everything's generally accepted accounting principles, but that has a certain connotation to it.
And smaller businesses may not use GAAP, or they're not required to use GAAP, and it's expensive to go in and have GAAP compliance. And so in a deal context where the buyer may want you to make a representation that your financials are prepared in accordance with GAAP, and they're not, you can't make that rep. So you have to be able to explain what you're doing. Most of the time, once the explanation is out there, the buyer can get comfortable with the accounting standards used. But I think the starting point in most deals is GAAP, and then you got to figure out how to explain how you deviate from GAAP, and make sure the buyer is comfortable. You don't want to be in a situation where you just sign a document that says you're GAAP compliant and you're not, and you've got a whole bunch of issues after the fact.
And if you're going to anybody for money, you should have not only a legal relationship, but you should really have an accounting relationship with somebody. I mean, unless you're really an expert yourself, because accounting issues, human resources issues, problems with employees, employment claims that are potentially out there. They fall in line, along with regulatory issues on things that could just be problems. And a buyer coming into something, they don't want to, a buyer, a lender, again, we're using the context of buyer, but anybody coming into a business relationship, even if it's a lending relationship, does not want to get into bed with a company that has potential problems and may not be around. Regulatory issues, if you're in a regulated business, and if you don't think you're in a regulated business, you want to make sure that you are. Obviously, if you're medical, if you're in any type of health-related products, probably regulated.
Financial services.
Financial services, and that's another issue. You want to make sure that you are in full compliance. Anywhere where you're not is going to be a potential problem, either in the deal or after the deal.
On point 5, your third-party issues and transferability. You and I were talking about this earlier, is kind of how to position your documents to make the sale process a little bit easier. And so sometimes it's a boilerplate provision in a lot of contracts. This contract can't be assigned, or it can be assigned, or you have to have third-party consent to assign. Those are often buried in the fine print that nobody really looks at unless there's a problem. And so if you're trying to kind of head things off at the pass, if you do have an intention to sell your business at some point, you may want to add language that you may not be able to assign it unless, or the counterparty may not be comfortable with you just having a free write-up assignment. They're hiring you to do something for a specific reason, but the language could be tailored such that you can assign freely if it's part of the sale of your business, and that'll help alleviate some of these hurdles that come up in these disposition transactions.
And that's a provision. We were just talking about this because it's come up in a deal where we see some standard contracts. Like, gosh, if you just had that language, it would be so much easier.
Right.
And now we're trying to have to figure out how to deal with it. Maybe we can assign anyway. I like to write that into contracts. Again, it's a reason why to, at least have somebody take a look at the contract on the front side. I've never gotten pushback on it. Anytime I've put it in, I've never had anybody.
Well, people aren't thinking at the time, it's like, okay, it's a kind of a.
Like, look, if I sell the business to somebody, or if I
something
sell all my assets to somebody, I want to be able to assign this contract to them. And especially in technology, it's very common because that's the expectation. If you have a technology business that takes off, there could be a buyer, and you want to be able to assign an agreement to the buyer.
I do want to hit on, before we go, some assets just can't transfer. Licenses, certain things that are particular to a person. I guess the easiest example for us as lawyers is your law license. It doesn't transfer. So if somebody wanted to buy a law practice, lawyer A wants to buy lawyer B's law practice. You can buy the client, you can buy the book of business, but you can't buy the license. And so if a deal has an earn-out provision, meaning that the seller is going to be paid based on, at least in part, on the future performance of the company, you want to make sure that the company can run the business post-closing. So you're going to want to make sure as a seller, they have all the licenses that they need to be able to create the revenue that's going to pay your earn-out. And so again, you can't transfer something like a professional license. You want to make sure that's clear in the documentation, that that's not going over to the buyer.
That's a great point as well. And all right, so we've got a short amount of time, and I want to make sure we at least touch on the chart and explain what that is. The seller reps and warranties, there's a lot in here. This is I think Kathryn would say that this is probably, we'd say, the most heavily negotiated area of a contract.
It is, and because it's the greatest area of exposure to the seller. The reps and warrant, they're really there to allocate risk between seller and buyer. And so as a seller, you're going to be asked to give your business a clean bill of health, and the buyer is going to want representations to that effect. And no business is perfect, so it's going to be very difficult to give unqualified representations and warranties. So one of the things that we try to do is to put in materiality and knowledge, saying, okay, it's, even if there's a breach, it's immaterial, or I can only represent and warrant something that I have knowledge about. So there are ways to kind of limit the exposure there, but that and the indemnification provisions are usually the most heavily negotiated parts of a deal.
And when people say that, somebody recently said, why is it so expensive? Like, what's involved in selling? Which is odd if you think about it, because people think nothing about paying 10% closing costs to sell a house, which is just sitting there, and it's pretty easy to do a title search. And, selling a house, especially in this market, there's nothing to it. I should say there's nothing to it, but the contract is a form contract. It's not a very involved process. Commercial real estate is a little different. But with a business, there's all these unknowns. It's not that easy to go out and search what issues are out there. And so Kathryn mentioned qualifiers and knowledge. The seller's knowledge of what has happened versus things that could have happened a seller doesn't know about. There could be a huge difference there and a huge gap. And that gap could mean a difference in potentially hundreds of thousands of dollars of later claims against a business. So we've listed out several common reps and warranties that you see in agreements. And it kind of goes back to, I think these are reflective of what we talked about earlier in our session today, that, the reason those documents are important and the reason you want to get the relationship right early on is that later, when somebody's evaluating your business for whatever purpose, when you're asking somebody for money, either sales money or lending or investment, they're going to want you to represent and warrant that you have these things in place. And if you don't, then you need to identify them. And when you identify them, it's going to affect the deal. There's your knowledge qualifiers that you mentioned. So, knowledge of the seller, this is another big area of negotiation. We want to make sure with knowledge, you're at least saying, look, I can only make representations and warranties about the things that I know about. The question then becomes, well, if you're selling a business and you've been operating it for all these years, what should you know about? But again, this is a huge area of negotiation. Materiality, you got that there. We talked about that. All right. What's our next?
We're kind of in the, I think we're in the real life examples
you want to go
part now.
in the chart?
Sure.
Okay.
So, we're not going to go through all of these.
We've got a few minutes. We can take questions and we'll ask. I'll let Kathryn kind of explain what this is, and you can look through it yourself. And If you have questions afterwards, again, fire those questions back to us.
So this, I mean, this is a diligence inquiry that we have seen a buyer propound to the seller. And so in this slide here, I wanted to call out section 1.2. They want a list of owned and licensed trademarks, brand names, etc. related to the target. Here, this is where your trademark and copyright registrations are going to come into play. You want to be able to produce, here's the registration, here's when we got it, we have no claims against it, and we've done what we can to protect it. 1.4 internet domains, there's so much going on online that a buyer wants to know, what domain you own or when it was registered to you, or they want to schedule so they know what they're buying, what names they're buying, and it ties into the brand. Hopefully you have your domain names that align with your brands, and it's evident to the buyer that they kind of come together. 1.5, unregistered IP rights. This is what Eric was talking about, where you don't need to have a registration to have, copyright or trademark protection. So keep be able to provide a description of your IP rights if they're not fully registered. 1.6, methods you use to protect trade secrets and know-how. Again, I think that goes into being aggressive. We need to be in litigation to make sure your IP is protected. The next slide here, I wanted to point out 1.8, work for hire. We talked about, again, the importance of documenting ownership of intellectual property. At 1.11, lawsuits. Lawsuits relating to your litigation and your IP. Again, if they're buying a brand for the most part, they want to know how you're protecting it and what's out there. And 1.13, agreements with web hosts, cloud storage, and other material vendor agreements. In tech companies, there's going to be a transition period, I think, and so when a buyer buys an IP-heavy company, they're going to want to know that they could continue to use certain aspects of the tech until they can migrate things to their own platform, to their own provider. So 1.13 is going to be something that a buyer is going to want to see.
I also want to point out on 1.12, we'll often see some language somewhere in a document, a rep and warranty, that you have acted in compliance with your privacy policy,
Right.
especially privacy. Everybody's so paranoid about security and privacy right now, and so they're going to want representations that you've been in compliance and will continue to be in compliance with your privacy policies and your other terms.
An interesting ask is sometimes that the privacy policy doesn't contemplate transfers of data.
Customer data.
The buyer may ask that be modified prior to closing. So that may be something when you're drafting these things or having someone draft them for you to have that in mind. It's okay. To the extent you're able to sell it, you want to be able to sell it and not have any hurdles. And if your policy doesn't already allow for assignment, so you want to build that in.
And another point on that with custom drafting, or at least taking a look and understanding what's in your own privacy policy, if there's something that's not in there or some change that you need to make, the way we typically will try to draft it when we're drafting for providers, for folks who have websites and platforms that people are using, we will draft in language that allows us to pretty freely and easily amend the privacy policies and the other policies that go along with the terms of service. And oftentimes those amendments will just take effect almost immediately upon posting a new document. But if you don't have that language, or if you have some language that says that the privacy policy is tied to a service contract that's a year-over-year contract, how are you going to amend that on a mass scale? So you really need to keep that in mind, and what types of things you need to be flexible about. You post a notice of an amendment online. Nobody's ever going to raise an issue about that, but if you don't have that right, you may have issues with it.
And on time, I think we're right
we've
on
got
time.
we're almost at 1 o'clock. I think we're kind of wrapping up. Here's the last couple. Anything on the last?
I think we just talked about it. 1.15, your data security policies, and again, sometimes the buyer may want an amendment to that to make sure that everything can transfer.
They also may want to see your vendors' security policies, or know that you have vetted your vendors to meet certain standards. And we've seen contracts that say you're meeting certain technology standards. And if you're relying on Google, the cloud, or Amazon web services to protect your information, better to just say we rely on AWS to protect our information, and we rely on their policies then to make a representation that you are protecting the data, because you're not. You're relying on somebody else. It doesn't mean you're not protecting it, but you can't necessarily make a representation if you're relying on a third party. And it's not all that uncommon nowadays to rely on a third party. You just want to make sure the reps that you're making are consistent with what you're actually doing. Because if you're not, and again, if a buyer buys a business and it doesn't turn out to be the business they thought it was going to be, which could be their own fault, by the way. But if they don't get out of it what they were hoping to get out of it, they're going to look to any type of holdback that they had, any type of seller financing, which you often ask for, promissory notes and other things. We didn't really get into that. That's different when you're structuring a deal. You want to have as much security, and we had a situation a few years ago where a buyer with no security got completely eaten alive because they weren't protected, and the deal changed 2 years after the deal was consummated, and there was nothing he could do about it because they didn't have any real recourse. But in any event, you as you're looking at this stuff, you want to make sure that all the representations you're making are consistent, because that's what somebody after the deal closes, if they're trying to get come back to you because they're not happy with the performance, they're going to take any misstatement, misrepresentation, anywhere where they can point out where you made this misrepresentation, which seems immaterial, but when they add them up, if you take a skilled, persuasive litigation type attorney, and I know folks who have drafted these, I feel like I've drafted them myself, and say, you lied about this, you lied about this, you lied about this, what else did you lie about? And by the way, we're not going to pay you that $1 million promissory note because you lied, the business suffered because of it. Anything else for today? We are right at 1 o'clock.
Right.
This is, let's see, I think we had meeting. Thank you. Actually, somebody I owe some responses to some folks out here. But yes, I'll get you a copy of the full video once that's available. It should be soon. And thank you again, folks. Have a great day.
Thank you.
1 p.m.